Good morning. This is Ezer Nguono, an advocate of the High Court of Kenya, currently practicing in Kenya. So today I'm here to do an explainer. And the explainer is specifically for a topic called declared unfit to take plea in murder. So some people, I know some of you have had different cases and very controversial cases happening. And in most cases, these controversial cases are the ones of murder. And you've had people being taken for mental assessment. So I'm sure you may ask yourself, what happens when one is taken for mental assessment, then he or she is found to be insane? So here is an explanation, probably a brief explanation of what happens when you're declared insane. So first of all, we have to refer to insanity legally. What is insanity? And you might hear in court some of the people referring it to non-composed mentees. So non-composed mentees basically is a term used to state that you are not mentally sane. So when you're mentally sane, you'll see the court referring you to as composed mentees, or some of the advocates saying composed mentees means that you're mentally or legally sane. But when you're non-composed mentees, it means you are not legally sane. So the directions taken by court normally, now that we have these different circumstances, you will see in courts, especially in serious cases where we call felony. First of all, someone's mental capacity has to be checked. The first thing you come to court, especially for a case, for example, I mostly use a case of murder. If you come to court in a case of murder, the first thing the court might tell you after taking plea, basically we can do it in the next explainer. But the first thing you do after taking plea, the court may refer you to a mental institution for checkup. Some of the courts are very specific, especially in Kenya, we are very specific in the types of hospitals that you're taken for mental checkup, because there are specific hospitals with that capacity. So in Kenya, mostly people go to Mathari Hospital. And for quite a number of times, we have also appeared in court where you see people being referred to Magathi. But in most cases, persons are taken to Mathari Hospital for assessment. So that is the first direction court gives. Secondly, the court might direct for a pre-bail report. So they may come concurrently and the court makes a decision to it on what happens after you have been found sane or insane. So normally when you have been found sane, the process is still the same. You continue with the case as it is. But now the explanation for today is, what if you are found insane at this time? So insanity in criminal cases is one of the defenses that is used in criminal cases, specifically in criminal cases. So just for purposes of explanation, defenses are things that might exonerate you in a case or might find you not guilty in a case. Some of the defenses we use in criminal cases, probably you might need to know intoxication, alibi. By alibi, we mean someone saying that you were not present at that time, at that specific place where, for example, a murder is claimed to have happened. So we have several defenses that one may plead: necessity. So under these defenses, insanity is one of them. And in this specific case of insanity, you have to prove, the courts have declared that you have to prove that at the time of the occurrence of the incident. For example, you are claiming, the prosecution is claiming that there was a murder case that happened at 4 a.m. somewhere probably in Nairobi town. You have to show that at that period, you were not in the right mental state, or you were insane at the time of commission of that offense. So some of you may ask yourselves, what happens when probably you become insane after the act? Now that's different. Some of the courts have argued that you cannot plead insanity after the fact. So the main things that we concentrate at is what happened when the offense was committed. Were you insane? Were you not insane? So you may ask yourself also that at the time you're being treated or being investigated whether you're insane, it is after the fact. For example, you have been charged today, yet the offense happened yesterday. So the psychiatrist will check and confirm. Now, when you are coming to court, it is also for the defense to prove that at that time of the offense, you are also insane. So this brings me to something that I have to mention. In criminal cases, it is said that the prosecution must prove what we call beyond reasonable doubt. That if you have a doubt or the magistrate has a doubt on any evidence given, you must acquit or release that person. But in criminal cases now, you have to prove beyond reasonable doubt, and that onus or that burden is on the prosecution. But when you are proving the defense of insanity, that burden of proving that this person was insane is not on the prosecution. It is on the one claiming. For example, if I am with my client and my client is claiming that he was insane, or the family informs me that this person was insane at that time, it is my duty now to come to court and prove that defense that my client was insane at that time. It is not on the prosecution. So when you are raising it, especially for lawyers or any person who intends to represent himself, be aware that you have not shifted that burden to the prosecution. It is upon you by yourself to prove that this person was insane at that time. So this also brings me to the specific section that deals with insanity. So in Kenya, we have what is called the Criminal Procedure Code. So under the Criminal Procedure Code, it defines or gives some number of issues on how we are handling criminal cases. And in this, it has also declared, under, I believe, Section 166, the defense of insanity. And it has explained what happens in the event one is found insane, one is believed to be insane. So you may ask yourself now, in this scenario, what happens when you have been found insane? So when the normal process starts, you have already taken plea. After taking plea, you have the mental assessment has been undertaken. You have been found that you are insane. Now the court declares you officially insane. After you have been declared officially insane, a report is made. A report or an order is given. This report is sent, according to the code, the report is to be sent to the president. Although we have to appreciate that these are things that were written long time ago. So reference to the president at this point, at times it refers to very many things. The president may not directly do it, but it might be a delegation. So when this order is referred to the president gives a declaration on where you are going to be held. In most cases, and just to disqualify this thought that we have, normally the citizens believe that you are taken automatically to a mental institution. But that is not the wording of the code. It gives an option, either a mental institution or even prison, or it states a suitable premise. The most reasonable place to be taken to is now a mental institution. Now, another thing we have to ask ourselves, after you have been taken to a mental institution, for what duration do you have to sit at this place? Now, according to the Act, there is no specific duration that you have to be there. But it has been explained that an assessment might be done regularly, and the regular period is for a period of 2 years. For these 2 years, there will be an assessment by a psychiatrist if you have been rehabilitated, because we all know the purpose of you staying under that mental institution is for rehabilitation and for the purpose of the safety of the public. Because when this person has been declared insane and has committed a crime, there is fear that if he continues to stay there, there might be repeated action. For example, if someone has murdered yet he is insane, there is fear that if he is released and he has not been treated, the same thing might happen to someone else. So after 2 years, there is a psychiatric assessment on whether you are fit to be released. But there is also a clause under that section that it does not have to be that 2 years. The president might direct at any time for your release. So it might be earlier than that. You might be released even earlier, before the 2 years period. So just for you to get the clarity, and for those who want to refer this thing to different, you want to be more knowledgeable on this, I want you to look at the main case that most of the advocates refer to as the first of initial case. We call it the Manhattan case. So just a brief explainer so that you appreciate it. So long time ago, we did not used to have this as a defense. But in this Manhattan case, the defense advocates brought a very challenging and very interesting narrative at that time, that this person was insane. So apparently it was a very big case where this Manhattan shot someone thinking that this was the Prime Minister of, I believe that was England, but it was as the Secretary of the Prime Minister. So when he was brought to court, the defense lawyers properly argued that this person has been having these lunatic or these lucid moments where he believes that people are following him and he ought to have committed that offense to save himself. So for that duration, the defense lawyers proved that this person was insane, and the court agreed with them. Although it brought a lot of public outcry, and severally courts have tried to bring this different narrative and also improve this rule. So the rule has been improved severally by bringing in new things. So in Kenya, we have the most referred case that we look at. We call it the Wakesho versus Republic case, which is a court of appeal case. In this case, we saw the court of appeal appreciating that one can be legally insane. So what do you mean by legally insane in this case? In this case, the court stated that despite the fact that there were challenging documents being brought that this person was insane, his conduct in the matter showed that this person had a problem, and this problem could be assumed to be an insanity case. So the court declared that you cannot charge someone who is insane and find him guilty. The court directed that despite these clauses that we have been having, where it was stated that you are guilty but you are insane, the court challenged that aspect and brought a new thing. So it's a very interesting case. You need to have a look at it. The court stated that under Article 50, which we just state that it speaks to right of a fair trial and everything involving an accused person. If an accused person is said to be insane and you find him guilty but insane, it means this person had no capacity to defend himself, but you have found him guilty. So the court directed that it is proper, instead of saying guilty but insane, you can say that this person is legally, in light of the requirements of criminal responsibility or capability, that this person is not criminally liable. So it removes the aspect of this person being guilty, because this person cannot go to the steps that are required under fair trial. He does not appreciate what is happening at that moment. So I have also learned that this is the right way. The court properly directed itself, because this person cannot properly defend himself under the rights of a person, an accused person, over free trial. So you can have a look at it. I will challenge. It's a very short judgment, but very nice. Have a look at it. So under this case, we have also developed certain measures. Courts have taken certain measures to show that this and this are what you can do to prove insanity. But just to challenge you also, you need to know that insanity, in very rare cases, can you prove insanity? And according to the statistics, although we are not aware of the Kenyan statistics, but according to American statistics, only 25% out of 100 of the defense of insanity goes through. So some lawyers have learned the trick. You need to at least put several things apart from insanity, because it might not go through as you expect. So, for example, the Court of Appeal case, there was an issue of provocation together with insanity. So it is proper that as you claim for insanity, you need to have a backup to it, just in case this specific defense does not apply. And if you intend to use this defense of insanity, you need to be aware of the specific disease you're claiming. And if it's a disease, you need to explain to court, is it a temporary thing? Is it something this person has been suffering from? For example, some of the known diseases that the court has taken in this defense of insanity, such things are like schizophrenia, the court has accepted. But we have seen a general trend where people are bringing in new forms of claim of insanity. For example, people have tried the issue of PTSD. We also understand people have hormonal imbalances. So people are trying to bring new aspects, but which can be challenged. So it is my advice to you, as you plan to bring this defense of insanity, you need to be a little bit careful. You need to do proper research so that when you challenge the court with this type of defense, the court can appreciate the specific thing that you're doing. Lastly, I have to inform you that there are some of the defenses that have to be brought early enough. So you cannot claim insanity. Courts have ruled that it is hard for you to bring insanity when you are at your defense and you're claiming this person is insane. So it is proper that you bring it to court early enough. For example, the case of the Court of Appeal that I have told you, which was a Mombasa case, the correct reference is Wakesho versus Republic 2021, Court of Appeal in Mombasa. So the courts also challenged these people that this defense should be brought early enough, just like a defense we call alibi, so that from the beginning, these people can know that you intend to rely on this type of defense, so that it is not challenged at the end and someone claims that he wants a retrial on that basis. So we need to expand this and do more research, because it is a very limited field and very few people have tried to pursue it. So I challenge you to also do more research, bring more evidence, bring more cases, precedences, and also try to argue it in court so that it expands the legal knowledge and the legal, at least the legal backup that we might have in proving certain cases. Thank you so much for your time, and we hope that the next explainer will also join us and appreciate it. Thank you so much.